Good morning. This is Senate Judiciary. We're back again. And we've been taking up what I would call S58, the Public Safety Bill. Bill number, which has a number of initiatives have been added to it regarding public safety, such as evictions and rent and dealing with people who put in danger other apartment owners, and also raise the age, as well as an proposed expansion of the Big 12, which are the most serious crimes in Vermont, which a youth from 14 up from 14 years old can be charged with under Vermont law, and it's critical to put in perspective how it fits with raise the age, in my mind. Raise the age is successful because there is, in my mind, the Big 12, which handles the more difficult cases, charges, even though those kids can end up in youthful offender status and be dealt with in the juvenile system. There is the opportunity to have them dealt with in the adult system. So, I think the two go along hand in hand. And so one of the proposals that we have in front of us would be on the Big 12, and that's a two-pager that Eric handed out earlier along with the raise the age. Does everybody have that one pager?
I'm sure. Yeah, yeah.
So maybe Eric, you could, I think we've been through it, but we could go over it again and then get some testimony from, we've already heard. Well, I don't know who we've heard from. We haven't.
Sure, I can walk the committee through the proposal. Thank you, Senator Sears. Eric Fitzpatrick with the Office of Legislative Counsel, talking about a proposal to modify the Big 12. And as Senator Sears was saying, when the Big 12 refers to what in current law are 12 offenses, where if they're committed by a young person, the proceeding starts in the criminal division of the Superior Court as opposed to the family division. Other offenses, when they're committed by a juvenile, start in the family division, but there's a certain list of offenses which over time has come to be called the Big 12, where if a person commits it, then the offense begins in the criminal division. As Senator Sears was saying, the age has changed a little bit over time as to what offenses start in the family division as a result of raise the age. So it used to be that if it were a non-Big 12 offense, it starts in the family division if the youth is 17 or younger. Starting in 2020, that bumped up 1 year to age 18 or younger. So under current law, anyone age 18 or younger who commits a non-Big 12 offense starts in the family division. What you just were talking about earlier this morning is when does that become 19 or younger to start in the family division, and still discussing that issue, but still at some point in time, the idea is that ages 19 and younger offenses for non-Big 12 offenses start in the family division as well. So that would mean that the Big 12 is also very much related to how old the person is when they commit it. As Senator Sears was saying, the current Big 12, and this is if you look at the one-page handout again, if it's an offense that is on that Big 12 list and is committed by someone who's attained 14 years of age, but not 22, that's the non-underline, that's like the second and third lines on the page. So if the child has attained 14 but not 22, that means 14 to 21, that starts in the criminal division. The proposal that, and that applies to the current Big 12. The proposal here is essentially to add 3 offenses to the Big 12 and take 1 away. So that results in a net gain of 2, right? Because if you add 3 new ones, take 1 of the existing ones away, that leaves you with 2 more. And the difference, though, with the ones that we're proposing to be added, and that's on page 1, you see, if you look Read subdivision 3. Any proceeding concerning a child who was alleged to have committed one of the following acts after attaining 16 years of age. See that's different than the Big 12 that I just mentioned, because it doesn't apply to 14 and 15 years olds. So it'd be 16 years of age and older. If any one of those 3 listed offenses, you see Roman numeral 1, 2, 3. So if it were a 14 or 15-year-old who committed one of those 3 offenses, those would still start in the family division. This only applies. So it's different than the way the Big 12 operates, in that anyone 14 years of age or older for the other Big 12 offenses starts in the criminal division. For these 3 that you see on page 1, it would only be 16 years of age and older. And those 3 offenses are using a firearm while committing a felony. So we talked about the using terminology earlier this week. Trafficking a regulated drug, and aggravated stalking. It used to, proposal formerly included human trafficking as well, but that's been struck. So the 3 new ones, at least for purposes of 16 years of age and up, are those 3 listed ones that I just described. If you turn the page, though, to the other side, you'll see, well, those are the 3 new ones. What's the one taken away? You'll see that's the very bottom of the second page, burglary into an occupied dwelling. The proposal is to strike that one from the Big 12. And you would only have 11 in this list, plus the 3 on the other side, which would leave you essentially with 14. So it's starting the criminal division. And the reason that sort of from a technical perspective, why these are added in a separate subdivision of the statute, as opposed to just adding them as numbers, 12, 13, and 14 of the Big 12, is because of the fact that the age is different. That 16 years of age makes it technically, it wouldn't work to fit it into the current list. So it has to be, the effect is the same. It's just done in a different subsection of the statute. So I think that's the gist of the proposal.
Sounds like. So, any questions for Eric?
I got it. Well, I don't, for Eric or for yourself or whatever else, I don't have any problems with it, but I'm just, I guess, a little bit surprised that using a firearm while committing a felony is, if we've raised that from 14 to 16. You don't have any 14 or 15-year-olds where you're from running around there?
We may.
Oh, okay, just.
This was an attempt at compromise. The concern is that you can still be moved up. But what I heard was more the 16 and 17-year-olds concern from police and law enforcement was more about 16 and 17-year-olds who were being brought in from out of state.
Okay.
Well, and this doesn't, these 3 don't exist in statute now, so it doesn't raise the age, we're adding them, so it's not raising the age at all, it's adding them for a different group of people.
Right, they're not currently Big 12, although any crime can be taken up to adult felonies.
Non-Big 12 felonies.
Right, well, yeah, any what?
And non-Big 12 felonies can be
Any
taken up.
non-Big 12 felonies, so any one of these currently can be taken up, but it's not a simple process.
Yeah, I certainly have made the proposal that we raise the age to 16 for everything, but these 3 don't exist currently.
And I neglected to mention, apologies, that Big 12 offenses or these 3 don't have to be filed in the criminal division. They could, there's what's known as the direct file option. The state's attorney at the outset can choose to file them in the family division as a youthful offender proceeding. So that's an option at the beginning.
I think that I don't know if anybody is, Tim is out and wants to speak to this, or but Tucker, are you there? Would you like to speak to this?
I am here.
Yes, sir.
Morning, Senators. Tucker Jones with the Department of Public Safety. Senator Sears, I was coming in this morning to chat about the knowledge element, or that's what I thought you might want some comments on, but this is I'll just comment on the expansion of the Big 12 offenses generally. The logic here is to address the circumstances in which the behavior of these younger people are presenting an acute public safety risk right away. And so it gives the state's attorney the option to file directly in the criminal division right away and use the tools of the criminal division to essentially secure and buy some time with the youth to figure out how to proceed and to protect public safety right away. But, as Eric mentioned, it also allows the state's attorney discretion to proceed as a youthful offender proceeding right away if the public safety risk isn't as acute or emergent. What this is doing in part is taking away the ability of the prosecutor to proceed with a criminal case from the beginning for a burglary into an occupied dwelling for these younger ages. So we would, if someone is committing burglary into an occupied dwelling and the circumstances of that case presents an acute public safety risk, they would be unable to avail themselves immediately of the tools of the criminal system to secure the youth and protect public safety, and they'd be relying on the juvenile system from the beginning. And so that's just a flag. I know, of course, later on you can transfer, both directions over time. And that's why I emphasize that, this is really not about the ultimate disposition of the case. It's about where they originate. And the reason there's a value in having the option to originate in the criminal division is to avail the prosecutor of the immediate tools in the criminal system to protect public safety right after the event has occurred. So I'm just flagging that I could imagine circumstances in which burglary into an occupied dwelling could present an emergent and acute public safety risk in the even if it was committed by a younger person, and that they would not be able to avail themselves of the immediate tools of the criminal justice system to secure that youth and protect public safety. That's been, yep.
Might explain the genesis of this, and then it might make more sense. And I can't find the paper with the numbers on it.
I was wondering about the same thing.
Right off the top of my hand. It started out with, my first proposal was to have it currently occupied dwelling. So the concern was the deer camp out in the woods that's nobody occupies except during hunting season, and it's somebody gets charged as an adult for breaking into that, looking for a bottle of whiskey or something. That was what the first goal was. So I put together an amendment to do what you see, and there we go, we have that numbers. And then the numbers in front of you are for the various years, and we found it was almost hardly ever used. So the committee recommended striking that section. That was done by a vote of the committee. Since there had only been four
in the course of 5 years.
in 4 of them.
Actually,
4, 5,
7.
6, 7.
Well, 14 to 16.
7 over a period of 5 years.
Oh, yeah, we struck entirely.
I think there's another line there, but anyway.
So the numbers up top are the ages, 14, 15, 16, 17.
Oh, the ages of the kid.
And that's from the years of 2018 to 2023.
Okay, so there's only been 1, 2, 3, 4, 5, 6, 7 charges between 2018 and 2023. So that's why the committee decided to eliminate that number 12. It was
I,
all
I
part of, it
understand. And,
was all a compromised position here. There was groups, there were members of the committee that didn't want to expand the Big 12. There were members that wanted to expand it. This is the compromise we settled on. I know it doesn't satisfy.
no,
But it-
I know, I understand it's a compromise, Senator, and thank you for, walking through it. I do think, if you recall, it was last session that this came up of the expansion of the Big 12. Right, first time in this committee and with Bennington PD explaining the circumstances they had. And I do think using a firearm while committing a felony, that's going to be really the important one, because as I was talking about how you can have an acute and emergent public safety risk, that's one of the offenses when there's a firearm involved, in which that can really be the case. So I do think that's an important, characteristic here. But at this point, I'm just giving comments, so I can stop.
Yeah, I understand. I think it's I agree. Probably the most critical one, and was the one that I felt last year we had, I was disappointed that the House wouldn't agree with it, because it is a serious thing. And if a young person, 16, were breaking into a occupied dwelling and using a firearm, they could be charged as an adult. Any other comments? I think Michelle took Tim away.
I'll go get them.
Did you want to comment about
On the current proposal?
what? Yeah.
No, I think just to say quickly that, as we said in our testimony before, we're not in favor of adding any class to the Big 12. So,
Tim, would you like to comment on the Big 12 additions on behalf of the state attorneys?
Yeah, sure.
Have you seen the proposal?
I believe, Tim, if you want for the record, I believe so.
If you could let them.
It's still got the additions.
Yeah,
It's basically,
Oh, so these are the ones, the 3 that are 16 and up. You're adding another 4 to the Big 12 or
No,
Three, and then,
the effective is to add to the Big 12. It doesn't go, it's going to a separate section for a technical reason, but it does add 4, 16 and up.
removing the occupied dwelling.
So you'd end up with a big 14 essentially, 11 minus 1 plus 3.
I think so, yes. I think so. I mean, obviously, we think it would be potentially, I think I put it in my published piece, that it's helpful to put it all in, wherever you're putting the addition, putting it in the one section that currently has the Big 12 makes, I'm not sure why we wouldn't just add to where the Big 12 is.
Because it's technically impossible. It doesn't, because this is only for 16 and older, Big 12 is for 14 and up. Try and work it in there.
For those who are watching, they are arguing a technicality.
Because of the age change.
Correct.
That's why.
Exactly.
If you want it all in the same section, we could raise the age to 16 for everything.
That would logistically work.
Yeah, so we would.
Or,
Yeah. All of these are
Go back to the other way.
counter,
These are all policy calls. I think we appreciate the additions that you're contemplating. I think that the majority of our department would be opposed to removing the burglary piece, but I know you've heard that from me before. I think adding in the word attempted into any of the additions aligns with what you did last year, because a judge may look at what you did last year, adding attempt, and look at what you're doing this year and not seeing attempt and say, oh, that was on purpose. So just as a point of consistency from last year. And I think that was it on the big, I mean, obviously these are policy calls for you all. I appreciate the discussion on this.
Let me explain on the occupied dwelling.
Okay, thank you.
That was removed by the committee after seeing information that there'd only been 7 charges between 2018 and 2023.
Under the Big 12.
Under the Big 12. And
May I respond to that?
only 2 of them were 14 and 15-year-olds. The remainder were over that age. And if you're using a firearm while committing that felony, you would now be covered if you're 16. So the charge, if they have a firearm, it's right behind you now, Tim. 3 17-year-olds, 2 16-year-olds, and 2 14 or 15-year-olds have been charged for the last 5 years. So the charges are few and far between in adult court. And the idea here from the committee, when we first proposed that it was going to be limiting to currently occupied dwelling, and the committee then decided to move to strike that section. But the understanding is that if you're using a firearm and you're 16 or 17, when you break into an occupied dwelling, you could be charged as an adult.
I understand the way that you guys have gone.
I understand your opposition. We expected that, but frankly, there's been few people charged.
Yeah, when I mentioned that, as I heard that statistic the other day, it means that they were potentially of a nature where, because of most of the cases for young folks we're trying to deal with in a rehabilitative fashion, they may have been so raised to such a level that they were filed in that manner that I wouldn't know without looking at each case specifically, or what other charges accompanied those. I understand what you're saying. Yep.
This was some members of the committee were for this, some were against it, but the majority supported the removal of that.
And I understand the reasoning that you put in, because the decision has been to have the 16 and up for those 3 only, that you're putting it into, they still can be commenced originally in the criminal division, but they're in a separate section. But effectively, the big offenses have now been split into a slight two pathways depending on age.
Right, although the path does exist, it was added last year originally. I think remember there was a piece added, I think that you guys had asked for it, that someone who was charged with a violation of a condition of release
Yes.
for an underlying
When it's
12
when it's
offense.
hanging on to that other offense.
Yes,
Exactly.
it puts it, that's where this aligns, that puts it in that spot.
I'll make that. Thank you. I appreciate that.
So I mean, it's what we would have in a final draft. I realize that some members of the committee won't support this piece either, but hopefully the majority will.
Thank you, Mr. Chair. I appreciate that, and I appreciate all the time you've spent on this issue. I know the bill has changed quite a bit.
Another thorny issue is, right in the beginning of the bill, this is where Michelle comes in, Eric, if you want to.
Oh, right.
If you want to go back and enjoy yourself.
Thank you.
Do something else, whatever you like. We appreciate your time with us.
Yes, thank you. No, we went through a lot this morning, so
So-
thanks.
We're gonna go back to, you stay right there, Tim.
I'll stay here.
Senator Baruch,
Jim and I
kindly
were
give
having
you a chair.
some good conversations about this stuff out in the
All right,
hall,
so Tucker Jones is on the Zoom. Falco is in the room, and the thorny subject on page 2, line 6 is knowingly. And when I introduced the bill, it was my intent that it was knowingly, that one could assume it'd be pretty dumb if you didn't know there was fentanyl mixed in with the heroin or other drug you were selling. Hard to believe that you could say, I didn't know it was there, but evidently people were. And so that was what we were targeting, but the ACLU and others have brought to our attention that this goes well beyond the fentanyl statute. But on the other hand, I wanted to include xylazine, because that's very likely, and the health risks and overdose deaths from that are well documented. So I'm just looking for better clarity on how broad we need to be.
I'm happy to speak to that if that's
It
something.
says it's not illegal to possess fentanyl necessarily, or xylazine, by the way, even under this statute. How we go, make sure we got this right.
Yeah, so Mr. Chair, I think your definition of knowingly, it would apply to the whole chapter because it's in the definition section. And one of the issues that we've seen with the drug marketplace, as illustrated by an entry order that I quoted but did not cite because it's likely to potentially be sealed or expunged at some point in the future. So I'm citing the substance of it, but so as to not potentially run into an issue in the future, I didn't want to cite the actual case. But it was a recent case where, because of the nature of the drug marketplace, and this was the quote, Vermont has not recognized the willful blindness exception to the knowing mental state. The court understands the knowing mental state presents a substantial barrier to filing charges given the reality of the legal drug marketplace for opioids and the frequency of the presence of mixtures of regulated drugs. This issue is, however, a matter for the legislature. The issue, if you talked to me 5 years ago, I would say fentanyl was potentially increasing with respect to depressants, heroin, et cetera. It is now more and more ubiquitous with crack and cocaine substances, so stimulants. And so we're not getting pure cocaine and pure substances, perhaps as the movies of the 90s and early 2000s might indicate with respect to drug prosecution. We're getting mixtures that are increasingly complex. And having the knowing standard that you've suggested here aligns very closely with the federal standard, which has been in place by case law since 1993, at least in the Second Circuit, which I've supplied on page 2 of the memo I've provided. And in that case, the Second Circuit said, if you find beyond a reasonable doubt that the defendant was aware, and you'll recognize some of this language, that there was a high probability that she possessed a drug that is a controlled substance, but she deliberately and consciously avoided confirming this fact so she could deny knowledge if apprehended, then you may treat this deliberate avoidance as the equivalent of knowledge, unless you find the defendant actually believed that she was not possessing a drug that is a controlled substance. And I think your knowing standard is pretty close, the one that you've suggested here in the change to that federal language, which if a case were brought in federal court, that would be the standard that would apply to a drug prosecution. Needless to say, difficult to narrow the knowing standard for this chapter because drugs are not pure substances anymore. They're mixtures of things. And the mixture, including fentanyl and xylazine of today, may be new substances in the future. So the knowing standard of today will impact future prosecutions.
Questions for Tim? Tucker, anything to add to that?
The only thing I'll add, Tucker Jones with Department of Public Safety, the only thing I'd add, Senator Sears, is that, this is not an abstract issue in Vermont, unfortunately. And I think Tim was citing the trial court order, right? And it was a denial of PC, that probable cause from the get-go based on the charging affidavits, maybe, which in part dates back to a Vermont Supreme Court decision. And at the beginning of this session, I believe actually Tim went through this a little bit early on. The Supreme Court decision is State v. Rillo, 2020 VT 82. And in that case, the court said that a plea, this was a plea, lacked a factual basis because the factual basis did not include an admission that the defendant knew the drug sold or dispensed contained the substance, in this case fentanyl, at the time that he committed the crime. Because they said, because the defendant did not admit he knew at the time of the offense that the drug contained fentanyl, there was no factual basis for the plea, and the trial court erred in accepting the plea. So that was in the context of a plea and a factual basis analysis. But then what happened is a trial court denied probable cause for another drug case, citing the Rillo decision and saying, well, there's no evidence here that the individual had knowledge essentially of the chemical composition of the substance. And the problem is that no one has any actual knowledge of the chemical composition of the substances in the illicit drug market other than the chemists who test the substances after the fact, essentially. And so there's a mismatch between reality, in which people do not talk about purchasing fentanyl or purchasing heroin or purchasing cocaine. They talk about purchasing up or down or other terminology. And so that is the evidence that is gathered during the criminal investigation to determine that someone is actually participating in the illegal drug trade when they attempted to sell, for example, so many glassine bags containing down. That is the reality of the market. There is no evidence that's ever gathered that that individual had actual knowledge that the substance contained a particular chemical compound. And so the goal here is to recognize that reality across the Title 18 drug offenses, that it's actually not a knowledge standard for chemical composition. It's more of a recklessness standard in which the circumstances clearly demonstrate that this is someone that's participating in the illegal drug trade. And it's the circumstances of the case that demonstrate that. So it's just some additional context.
Michelle, could we get a copy of Willow?
Brillo, yeah, I actually
And
have it. I
also-
gave one to Senator
Yes,
Christian just a little bit, but I'll email that to you right now.
I'd like to know what, Tucker, if you have any information on other states and how they deal with this problem.
Well, this originally came up, so this is 2020 with Rillo, and then state's attorneys, and it was 2022 originally, that they came forward and said, oh, wait, this is an issue because Rillo's being interpreted this way in this trial court decision, and it's inconsistent with the reality in the field. And they raised it there. And the focus at that time, and what Tim was referencing, was how the feds think about this topic specifically. And it was that kind of willful blindness on the federal level and adapting that concept to the state level. So I don't think we necessarily went to the other states. We were looking at how the feds think about the mens rea in this context.
Thank you. Senator Sheen.
Thank you, Tucker. This kind of, this gets to a question I had earlier about really the difference between knowingly and the recklessness standard. And I just wanted to confirm or clarify, did you say that this is more so bringing the burden for the mens, or that it's bringing the mens rea from knowingly down to a recklessness standard?
It's more akin, it's more. Oh, sorry about that. I thought you were finished.
Oh, no, sorry, I cut you off. Go ahead.
It's more akin to that. It's more akin to that. It's one of those conscious avoidance, deliberate ignorance, recklessness. There's various terminologies that you could use. In Vermont, our mens reas would go from knowingly to recklessness. That's the one we typically use as the next level down. There's some other ways to describe it. The feds use their own terminology for the conscious avoidance. And then there's the deliberate ignorance. So I don't want to say it's 6 in one, half a dozen in the other, because there's some value in thinking about how they may differ, but I think the language in here captures it. And I do think it's important that this would be in the Title 18 definitions generally, because this issue is not specific to any particular substance. It's not particular to any chemical composition. This knowledge issue applies to all of the substances. No one would have knowledge of the chemical composition of any of them. It's not just fentanyl. you would say the same about heroin. You know, it's the circumstances surrounding the facts of the case that would demonstrate that this is an individual who was attempting to sell down in the illegal drug market based on the subject matter expertise of the investigating officer.
So one more question. So if somebody is picked up or arrested for possession of heroin and the lab test later comes back showing that there's heroin and fentanyl in it, will that person be charged both with possession of heroin and possession of fentanyl?
No, because there is no possession of fentanyl crime.
You could charge it as possession of a regulated drug, even though there's no possession of fentanyl crime in statute.
So possession of heroin and possession of a regulated drug would come due to the possession of a bag of both heroin and fentanyl.
Yeah, it would be the officers, and I'll let Tucker speak into an officer might approach that, but there's, as a prosecutor, I think we like to be truthful in our prosecutions as to what we're actually prosecuting. And if we know in that situation, if we know that the individual, there is such thing as pure fentanyl, it's sometimes cut into other things, but often it's this mix as you described. It would be a charging decision for a prosecutor to try to figure out where they had the best case.
We're in an interesting lane here because you're talking about, it could also be a pill.
That's correct. It could be pressed.
That doesn't necessarily, I mean, what they're seeing now on several reservations in the Southwest United States is Mexican cartels going in with pills loaded with fentanyl and selling them at a fairly high rate compared to what it costs to produce on the reservations.
Yeah, I went to an overdose scene 6 miles from here with a pressed pill of fentanyl.
Yeah. So it could be, we're thinking of bags, but it can be a pill, it can be anything.
Sure.
Other questions for either Tucker or Senator Housekeeping? No. I wanted to just read a letter for the record. It's in our Thursdays. Somehow it got into Thursday's committee webpage, and maybe it should be on today's.
On what it may be, yeah.
Yeah, it's from a woman. She says, please do everything you can to pass this bill to hold drug dealers accountable for their role in the death resulting from their dealings. I lost two precious sons, Dennis and Sean Thibault, on June 18th, 2015, to overdoses of pure fentanyl. Hardworking men, masters of their crafts, proud and strong, struck down at the start of this insidious plague here in Vermont. The loss is unbearable. The fatal dog was delivered to them by a career drug dealer, and I won't name him, who knew from an earlier non-fatal overdoses that very day that he was delivering death. It took 7 years to bring him to justice, only to have him serve a mere 17 months in jail. 17 months for killing two men, that's not justice. We want to make an impact on the scourge. This is affecting the entire world. We need to do what Vermont does best for others. We've been a leader in effective change for our country before. We absolutely need to take an aggressive approach to increasing overdoses that are killing our loved ones. I know you all have likely been affected by this loss, either directly or indirectly. Please take action in the name of those who lost to this unprecedented crisis. I'd like to have this statement become a permanent record of this bill. Thank you, Penny Thibault. And that's on the webpage. So Senator Childs.
I just wanted to,
Judge Childs.
just while we we have both Tucker and Tim here, I just wanted to make sure that everybody's questions are answered on the death resulting language, because I know that Senator Hashim and I were talking a little bit about that, and I just want to take advantage of having both the guys here on that. And so if you look at page, if you look at the selling or dispensing a regulated drug with death resulting, and subsection B, in particular, I mean, the others are just, I mean, it's all policy decision for you, but I was focused in on B, and there's two pieces there. One is saying that the fact that a dispensed or substance contains more than regulated drug, that is not a defense to this section. And then the other one being the permissive inference that the proximate cause of death is the person's use of the regulated drug if the drug contains fentanyl. And so I think that the key part there for you is the second sentence, which is what Senator Sears keeps talking about around the, the way that the drug supply is now, is that if, a drug is sold and it contains fentanyl, and permissive inference, remember, is something that can be offered to the jury, is that, kind of like, if A, then you may find B, right? So if you think about what you have permissive inference in your trafficking statutes, which is like if someone has a kilo or 5 kilos of cocaine, there's a permissive inference that they were trafficking, right? Or I think, isn't it that like, isn't
The
it?
automobile.
Automobile, right? So like if you have drugs in your car, there's kind of a permissive inference that, that you knew you were in possession of those drugs, right? So it's not, the jury doesn't necessarily have to accept that, right? So they have the ability, but it's kind of like, if A, then you may infer B. And so that's what you have with the inference, and that seems as though that's generally, what folks are in agreement with here. The part that I find a little confusing and I don't, is around the defense bit, which is because if you look at the lead-in language, this section shall apply only if the person's use of the regulated drug is the proximate cause of the person's death. I'm not sure that you need to say about that it shall not be a defense if if the substance contains one or more regulated drug because of the first line there, because if it's got 2 regulated drugs, then it seems to apply. So I'm not sure where that defense comes in. And I don't know, Tucker, whether or not you might be able to explain a little bit about why that language is important. I'm assuming so.
Yeah, the goal here, what this is trying to achieve is to ensure that in the polysubstance overdose fatality circumstance, which would be most of the overdose fatalities that you'd see today, that you can't essentially escape liability because it's a polysubstance overdose. And for example, the charge might be sale of fentanyl with death resulting, but the actual death is a result of a polysubstance overdose fatality. And just to expressly capture that fact, in statute in some form would be important, because the question will become, well, if it's charged as a fentanyl overdose, sale of fentanyl with overdose, then, we want to make sure that it recognizes the reality that fentanyl is one of the compounds that contributed to it, but it was that actual sale of that substance that resulted in it, if that makes sense. So it's really just capturing polysubstance.
Let me try to word it and tell me if I'm wrong. So what you're trying to do is saying, even though there was heroin and fentanyl mixed in and maybe a little xylazine, you can't argue that it was the heroin that caused the death and that's what the person wanted to buy and blah, blah, blah. You can't argue the death is a result of any one of those 3 drugs, and you can't argue which one it was.
That's right. And that is based partly on the issue that our drug offenses are siloed into individual drugs. And so the criminal charge is going to be based on one of the drugs death resulting. And as you just said, we just want to make sure we're still capturing the reality, even though our Title 18 offenses are siloed into individual drugs, that the overdose fatality itself is going to most likely be a polysubstance overdose fatality.
Well, if I can understand it, it then makes sense.
And
it doesn't make sense.
So the thing that I'm still grappling with is the second part of this, which starts on line 9, where it starts, there shall be a permissive inference that the proximate cause of death is the person's use of the regulated drug if the regulated drug contains fentanyl. And I was reading State versus Rounds, paragraph 24, which is citing the rules of evidence 303C, which states that the rule distinguishes between a presumed fact.
So the doctor prescribed an antibiotic for you. You take it twice a day for 10 days, and that was a CVS.
Sorry, I didn't think I put on speaker. I thought I was on regular.
Or
Now YouTube knows.
so 303C distinguishes between a presumed fact that establishes guilt or is an element of the offense and a fact that has a lesser effect. And as I'm reading this, proximate cause, I am assuming is an essential element of causing death resulting. And so I'm not sure I understand how this particular sentence can be put into law and frankly still be constitutional. Can you help me understand this, please?
Yes, and so I'm glad you were just citing what I was going to cite, which is Rule 303. So, the criminal code has a handful of permissive inferences strewn throughout it. And I think Michelle was just talking about a handful of them before. And the constitutional issue, I think it's just an instinct that you raised a few times earlier and you're raising now, which is that you don't want a permissive inference to shift the burden of proof onto a defendant because that smacks of a constitutional issue right there. And Rule 303 is written to capture that fact. It's designed to avoid the constitutional issue. So Vermont Rule of Evidence 303B1 says that a presumption operating against an accused person, a defendant, permits but does not require the trier of fact upon sufficient evidence of the basic fact to find the existence of the presumed fact. But a presumption does not shift to the accused the burden of producing evidence or of persuading the trier of fact that the presumed fact does not exist. So that's a little bit of clunky language, but it's designed to specifically address the constitutional instinct that you have, the constitutional concern that you are raising. And because permissive inferences are, not uncommon in the criminal code, they kind of comprehensively address the constitutional concern and the jury instruction issue right in the rules of evidence, and that would apply here as well.
So, and that kind of goes to my next question, which is, regarding the sufficient evidence, if going to the first sentence of this language, removing that defense, does that then affect the threshold of sufficient evidence in order to make this, in order to make B1 apply in the way that you're describing?
That's not, it's not the intent really to water it down. It's really that first sentence there is really solely to capture this issue that the charge is going to be based usually on one substance and the fatality is going to be multiple substances. The second sentence is recognizing that the fatality, the use of the drug is the proximate cause of death when it contains fentanyl. That permissive inference and the analysis under 303 and the jury instructions under 303 would follow if there's fentanyl in it. And obviously there, the concept is that the overdose fatalities are driven so much by fentanyl that it's recognizing the reality that it is contributing to whatever it is, 93% of the overdose fatalities in Vermont, or whatever it happens, whatever the statistics are. So I don't think they're necessarily, I don't think they water each other down necessarily. I don't think they're inconsistent with each other either.
All right, thank you.
Okay. Other questions for anyone?
Can I ask you what you would like to see in your next version of S58, since I know you've been doing a lot of work with Eric and
I'd like to see incorporated what, there's been a few changes on the report to DCF, by DCF that Eric's working on. I'd like to see that. I've asked John Gray to go into economic development, housing, hopefully schedule something to go in there on the termination of rental properties. And I'd like to see, a final version of this, of our original sections of the bill, which was section 1 and, well, that we took
I don't
out
think I have
section
any more
2.
changes to those. That's
I
why
don't
was
think
just-
we have any more changes to the death resulting or to this. And then,
And then I'm sorry, Big 12?
Big 12, I think,
Eric had me take
Eric
out that
has that
older
ready.
section. Okay, so new section of Big
so
12?
I'm trying to, let me just kind of go through my copy of 3.3 in a good order. I think your work is pretty well done, and other than maybe making some notes on this, but anyway, so I don't think there's any change in the first 3 pages. And then section 3, we've added section 1, there's no change in knowingly that I'm aware of. Section 2, there's no change in the xylazine. Section 3 is selling with death resulting, and I don't think there's any change there. So, and I think section 4, which is the unlawful drug activity in a dwelling / citation, I think we're pretty well settled on that. It's sections 5, 6, 7, and 8 that I hope joint, that general affairs, economic development, housing, and general affairs will go over. And then section 10 is the Big 12, and section 11 is the raise the age. I think I got that. So Eric is working on minor changes to those, and we should be ready for a final bill, hopefully, towards the end of next week. But I don't know what the schedule is like in general affairs. But it doesn't mean we can't vote it out, and they can't, and they could make changes.
Okay.
So I'm thinking, Ben, that we probably, who knows what Tuesday is gonna be like next week, so I'd like to change slightly the agenda for next week. It's okay with Senator Sheen. We have at 10:15, we have a break at 10:30 after we hear from Mike Pichek. And instead of having Michael Grady in at 10:45, why don't we put S58 in between 10:45 and 11:15?
Okay.
In case we don't get to it on Tuesday, and then we could vote on our sections of the bill. And
So what I'll do is
presumably Eric will be done. The only thing left would be the general affairs changes, if there's any.
right, so as soon as I get that language from Eric, I'll incorporate that. I'll take out all the highlighting, I'll send it through editing, and I'll send a copy out to everybody here and to Ben as well, and then.
And we should probably send a copy of what we've got to Matt Valerio and Chris Winters, which Eric would do. And
or Ben, or if I just send it to Ben, Ben can send it
Ben,
to.
send it.
He'll send, okay, all right.
Yeah, all, and, well, on the ACLU, and so they could comment when we come into the, next week, whichever day we get to, hopefully Wednesday. And then what we need to do, next week, we'll try to focus on bail.
Outstanding.
Pardon?
Outstanding.
Well, yeah, it is, and it's an interesting conundrum because trying to get through everything in 2 weeks is not easy. I was, thank everybody for the hard work. And, I think we've done some good work here, and hopefully it's something that the majority of the community can support.
Ready to adjourn, Senator?
Pardon?
Ready to adjourn?
I guess so, yes. Senator Norris is